ठीक है, सीरियल नंबर 1 जो मेन लिस्ट का है, ट्यूसडे इन सप्लीमेंट्री कॉज लिस्ट,
Tuesday he is not here, madam.
वेडनेसडे
After 14th, 16th, madam. On 20 or
इसका क्या
20
मतलब है?
कल फिर अपने तो ठीक है, कल और मंडे, और नहीं तो फिर 20 के बाद।
ऐसा नहीं होता है ना,
इसीलिए
हम भी बोल रहे हैं, कोर्ट पढ़ के आते हैं ना, ठीक है, वो चले गए, उनका पर्सनल रीजन है, देयर इज नो प्रॉब्लम अबाउट इट,
ट्यूसडे से वो
लेकिन
है
उसके
नहीं।
बाद आपके अनुसार उसके बाद कितना साल नहीं है,
ट्यूसडे से वो है नहीं यहाँ पर, इसलिए हम
इसका क्या मतलब है नहीं है, मतलब कहाँ जा रहे हैं? कोर्ट नहीं आएंगे, किसी कोर्ट में अपीयर नहीं होंगे,
नहीं होंगे।
फिर
नहीं ट्यूसडे से है, जो फैमिली थोड़ा सा प्रॉब्लम है, इसलिए ट्यूसडे, वेडनेसडे और थर्सडे, फ्राइडे 3 दिन है जो
ट्यूसडे से फ्राइडे 4 दिन हो गए
आउट ऑफ द स्टेशन है हमारे।
आउट ऑफ स्टेशन, तो फिर नेक्स्ट टू नेक्स्ट
मंडे है जो चाहे ट्यूसडे किसी दिन भी होगा,
ट्यूसडे रख सकते हैं ना, कमिंग ट्यूसडे
से ही बाहर है।
20th और 21st, ये ना मैडम, 20th या 21st।
चाहे कल सुन लिया, जो मंडे है जो
समय का चक्र आपके अनुसार नहीं घूमता है ना? अदर साइड कौन है?
अभी अपीयर नहीं।
ये वाला जो सीरियल नंबर 1 है उसको 20 तारीख को रख दीजिए, एट द रिक्वेस्ट ऑफ द appellant, the matter is adjourned to 20th of January 2025 to be taken up at 2:15. It is made clear that no further adjournment will be granted. नहीं आएंगे तो हम अपना रिकॉर्ड पढ़ के अपने ऑर्डर कर देंगे, किसी का जरूरत भी नहीं पड़ेगा हमको, ठीक है? 20 तारीख को
20 तारीख
20 की बजाय 21 तारीख को कर दीजिए,
20 तारीख
21 21 इन द सप्लीमेंट्री कॉज लिस्ट। हाँ बोलिए।
I am not feeling well. I have item number 5. I pray for not today.
आइटम नंबर 5 मेन लिस्ट,
Main daily list.
नॉट टुडे कर दीजिए। कब चाहिए आपको बताइए?
Next week कर देंगे.
ट्यूसडे को सप्लीमेंट्री कर दीजिए। नहीं ट्यूसडे को नहीं, वेडनेसडे को
Right.
supplementary list. At the request of the learned counsel for the appellant, the matter is adjourned and is directed to be posted on Wednesday in the supplementary list. Like
item 4 second appeal 167 of 2020.
पूछे आप
जी पूछ लिए थे.
क्या पूछे?
कह रहे कि हाँ वो तो जमीन जो है पोजीशन वाला वो तो हम रिलिंक्विश करने के लिए तैयार हैं, नॉर्थन साइड वाला तो दे देंगे.
The learned counsel for the appellant. The learned counsel for the appellant submits that the learned courts have recorded right, title and possession of the appellant in connection with the property covered under Sale deed number? Sale deed dated 11/7/81. Yeah.
हाँ
11/7/81, which was the northern portion of the property. Although no such relief as such was sought for by the plaintiff in that connection, nor the defendants claimed right over the same, although the sale deed was executed in favor of the defendants. They have submitted that the specific case of the defendants was that although the northern portion of the property was sold, but the plaintiffs permitted the petitioner to take possession of the southern portion instead of northern portion, in which the defendants have constructed their house. He has submitted that he has taken instructions from the client, who has informed him that they are not concerned with the northern portion of the property, which was subject matter of the sale deed. Rather, they are concerned only with the southern portion of the property. The learned counsel submits that since the defendants were put in possession of the southern portion of the property, the defendants also claimed adverse possession over the same. But no such issue was framed by the learned trial court or even by the learned appellate court. And therefore, an important issue which cropped up on the basis of plain and written statement of the parties was neither framed nor decided. And simply the learned court recorded that the plaintiff was in possession of the southern portion of the suit property. Although it was the specific case of the plaintiff that a portion of Schedule 2 of the property, which was mentioned in Schedule 3, was in possession of the defendant, and they had even sought recovery of possession of Schedule 3 property from the defendants. He has reiterated that property in Schedule 3 was a part of Schedule 2 property, and the learned court has declared right, title, interest and possession of the plaintiff with respect to the entire Schedule 2 property. Correct? यही है कहानी. He submits that the appeal be admitted. कहाँ बनाए हैं substantial question?
सब्सटेंशियल क्वेश्चन ए और बी है.
The learned counsel submits that the appeal be admitted for following substantial question of law. A. Whether the learned courts have erred in law in not framing any issue in connection with adverse possession as claimed by the defendants, and on that count whether the matter is fit to be remitted to the concerned court for framing an issue of adverse possession and deciding the same accordingly. Okay? Or B, whether the learned court has gone beyond the case of the respective parties while declaring right, title, interest and possession of the defendants in connection with northern portion of the property which was covered by the sale deed dated 11/7/1981. ठीक है?
हाँ, यही
कोई तो क्लेम
यही
तो
दो
ऐसा
question
था ही नहीं. It
हाँ।
was nobody's case.
हाँ, यही दो substantive question और
Let-
बात वाली limitation वाला तो था।
Barred by limitation तो क्या ही?
अब adverse possession हो ही गया तो फिर बात वाली limitation नहीं होगी।
Let notice be issued to considering the submissions made. This second appeal is admitted to be heard on the aforesaid substantial question of law.
Notice to
Let notice be issued to the respondent number.
1 to 11. 12 is the performer respondent. He is the sister of the plaintiff. May go to him.
सभी को जाने दीजिए.
Plaintiff ने
To the respondents under registered cover with AD and notice, and additionally notice to respondent number and additionally notice to all the respondents except respondent number 11 under ordinary process. वेस्ट बंगाल में रेस्पोंडेंट वहाँ से ऑर्डिनरी प्रोसेस का आने में बहुत ज़्यादा टाइम लग जाता है. ठीक है?
एक खाली बंगाल के
हाँ, उनको छोड़ दीजिए और बाकी सबका ऑर्डिनरी प्रोसेस भी फाइल कर दीजिए. The recusals be filed within 1 week.
within
Let the records be called for from the concerned court. Post this case on 20th March in supplementary cause list. Record आ जाएगा तो देखिए इतना हम सुन लिए हैं तो हम डिसाइड कर देंगे अगर पार्टी अपील हो जाएगा तो इसीलिए आप लोग तैयार हो जाइए. इसीलिए सुन के नोटिस करते हैं.
From supplementary list, this case item 6, second appeal 98 of 2017.
क्या करना है बताइए. कर दो. ऐड करना है. क्या ऐड करना है? Yes.
Lordship, there is a finding of fact that the registered deed through which I am claiming is not the same property which is the scheduled property. And their case is that I am claiming the schedule B property through an unregistered agreement. So I take that assumption and I advance my argument on the basis that the schedule B property that they are claiming, I am claiming it through an unregistered
You see,
agreement.
whatever they are arguing, you just during the course of arguments, many things transpire.
Yes.
So, yesterday his case was that the identity of the property under the registered deeds were held to be different, but the appellate court had ignored this finding and has returned certain findings, assuming that the identity of the property is one and the same. Right? So, if that be so, then under such circumstances, the matter has to be remanded because the appellate court has not considered this aspect of the matter. This is what we are looking at. And the other issues, whether there is an unregistered document, what is the consequence of unregistered document, for this property, whether that unregistered document is for one or the other property. These things will certainly fall for consideration if it is ultimately found that it is different property or it is the same property covered by the same deed. If it is covered by the same deed, then the appellate court's order will again come up, right? And if it is not covered by the same deed, if the property is not the same for both the deeds, then under such circumstances, the other materials on record, including that unregistered document, will be taken care of.
So that is what I am saying, that let me assume that the property is not covered by the registered sale deed. It is part of the unregistered agreement through which they are saying that I am claiming my property. Even if we take that, then also they don't have a case. That is what I am trying to show to your lordship. If your lordship.
Not in second appellate stage, because second appellate stage will go by the findings recorded by
Yes,
the
but I'm not trying to reappreciate facts. I'm only going in pure question of law. All the facts.
When the
all
facts are not clear
Yes.
and the appellate court has not recorded finding on a very important fact, then under such circumstances, how do we go into the facts and
The trial court, my lord, says the trial court has recorded a finding that the property, that the suit property, I am claiming it through an unregistered document, which was executed subsequent to the registered deed that was executed in my favor. So even if I take that fact finding to be true, there was only one argument I have. That fact finding is there, that I am claiming through an unregistered document in the trial court judgment.
yes.
Yes. So if your lordship may kindly see section 53 capital A of the transfer of property.
See, these issues we will not appreciate for the first time. The fact should be very, very clear before appreciating any question of law. If you go into 53, there are new issues will come.
My only submission, my lords, is that the 53, the documents that are covered by 53A, those documents are required to be registered pursuant to an amendment carried out in 2001. But before that, those documents were not required to be registered. And the agreement through which, if their case is taken to be true, if the trial court's finding is taken to be true,
First, the finding should come. First, the court should come with clear findings, and then only we can see whether, if ultimately the court holds that the identity of the property is different, and then the court enters into that particular unregistered document, then the court would examine what will happen to the plea regarding 53A. Who was in possession of the property? There is a finding on possession.
I have made out a case that subsequent to transfer of land through that
Because
agreement.
53A, there has to be a clear finding that one was put in possession of the property pursuant to that unregistered agreement. So those things will also crop up based on whatever nobody, there was no issue regarding 53A. We are not going to frame an issue which was not there again. Again, the same story will be repeated. That we will not do. Okay?
Mr. Rohit's name may be recorded.
It can't be. These are recorded proceedings. We can't do that. Second appeal number 98 of 2017. कल का ना पूरा डिटेल ऑर्डर लिखा है. In furtherance of the proceedings that was recorded in order dated 8/1/2025, the learned counsel for the respondents has submitted that even if the case of the appellant is taken into consideration, then also the respondents were put in possession of the property by virtue of the unregistered agreement dated 21/9/1991, and therefore the provision of Section 53A of the Transfer of Property Act would come into play, and consequently the factum of the agreement being unregistered has no consequence, correct?
Yes.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the learned trial court, having recorded a clear finding that the two exhibits, that is Exhibit 1 and Exhibit A, है ना?
Yes.
Were in relation to different properties, and the said finding has not been dealt with by the learned appellate court. And it appears that the learned appellate court proceeded by assuming that the identity of the property of Exhibit 1 and Exhibit A are one and the same, and also referred to Section 48 of the Transfer of Property Act to hold that the earlier sale deed is effective and would ride over the subsequent sale deed. This court finds that the approach of the learned appellate court was certainly not in accordance with the provisions of Order 41 Rule 31 of CPC, and therefore the substantial question of law as framed by Roman 6 in order dated 2/11/2018 is answered in favor of the appellant and against the respondents. So far as other issues which have been framed by this court on 2/11/2018 is concerned, the same would essentially depend upon a finding by the appellate court with regard to the fact as to whether the identity of the of the property in Exhibit 1 was same as Exhibit A. In the aforesaid facts and circumstances, the order under appeal, the judgment and decree under appeal is set aside, and the matter is remitted back to the learned appellate court for fresh decision in accordance with law. It will be open to the appellate court to frame fresh issues for determination in terms of the provisions of Order 41 Rule 31 of CPC, and after hearing the learned counsel for the parties to pass fresh judgment based on the materials already available on record. The parties to appear before the court, I'll just give a date
Yes.
for your appearance. From the date of appearance, the learned court shall decide the suit expeditiously, and suit कब का है? The appeal expeditiously कब का है suit?
2009.
1995 का
1995 का सूट है
95 का सूट
but not later than 3 months from the date of the appearance. और एक चीज़ और, एक ये जजमेंट को रेफर करेंगे SA 28 of 2017, right? Because we have called out all the judgments as to how the
several judgment has been taken into account.
several
There's
judgments
a-
have been taken into.
The,
Are
the
you
Patna
aware?
High Court judgment that has been referred. There's also a Supreme Court judgment on the same point. I'll just give a copy.
You just give a copy of that.
On the
It's a very recent judgment.
हाँ,
same line of Patna High Court judgment 85 Patna.
Order 41 rule 31.
हाँ, आप दे देंगे प्लीज। उस अपीलेंट के लिखिएगा द लर्नेड काउंसिल फॉर द अपीलेंट हैज referred to the judgment passed by this court in essay number 28 of 2017 decided on 2/1/2025 and has submitted that this court has laid down elaborately by referring to the other judgments as to how the first appeal is to be decided in terms of order 41 rule 31 of CPC. He undertakes to produce a copy of the judgment before the learned appellate or any other judgment with the parties may seek to rely. ठीक है? कुछ और रहेगा बाकी. I think this much should be sufficient. कल दिखाई दिए थे कल. Appellate court का judgment को satisfied judgment को लिखते हैं.
From Delhi is item 6, second appeal 190 of 2020.
Who is there for the appellant? Where is the appellant? Yes.
Your Ladies, just I'm telling it will come on Mondays. This Rahul Gupta will be appearing in this case because I couldn't assist him properly. That is, just I'm telling it will come on
आप
Monday.
लोग एडवांस नोटिस नहीं देते हैं ना. ऐसे कैसे जब मन होगा तब आप सेकेंड अपील जैसे असाइनमेंट में आप टाइम मांगते हैं. ऐसे नहीं हो सकता है. It can't be like this. You can't just come and pray for time like this. ऐसा नहीं हम परमिशन देते. 1,000 रुपये आपको ऑलरेडी कॉस्ट लगा हुआ है. अब कितना लगा दें? 1 0 और बढ़ा देते, 10,000 रुपये लगा देते, ठीक रहेगा. बताइए, ऐसे नहीं होता है ना. It can't be like this. Essay number 190 of 23. Learned counsel for the appellant pays for time. He submits that he has engaged a senior to argue this case and he is yet to be briefed. यही है? Earlier, when the case was taken up on 10/9/2024, the adjournment was given by way of last chance upon deposit of cost of ₹1,000. Today again the appellant is seeking adjournment without any prior intimation to the court. However, for the ends of justice, the matter is adjourned. बताइए कब करना है? And is directed to be posted on. बताइए
On Monday,
Monday नहीं होगा. 16th of January 2024. Subject to payment of cost of ₹5,000 to be deposited. By the appellant with Jharkhand State Legal Services Authority prior to the next date, failing which this appeal shall stand dismissed without further reference to the bench. If the proof of deposit of 5,000 with Jhalsa is furnished by the appellant by 15th, the matter will be listed on 16th of January under the same heading to be taken up at 2:15.
it is not at cost.
Cost and compulsory.
Item 7, second appeal 217 of 2020.
Lordship, in this case, counsel who has to argue, who has gone out of country for the treatment of his father.
कौन है आर्ग्यू? किनको आर्ग्यू करना?
गौरव कुमार
कोर्ट नहीं आ रहे?
ने गए हैं अब पिताजी को ट्रीटमेंट
कहाँ गए?
आर्मी हॉस्पिटल।
तो कब के लिए बोले हैं रखने के लिए?
आज के बाद कभी भी रखेंगे
कल वापस आ जाएंगे?
नेक्स्ट वीक।
क्या है बताइए? पढ़ लिए फाइल?
Is the Lordship, I am the caveator in this case.
बताइए क्या है मैटर? अब बैठ जाइए, आपको तो कुछ पता नहीं होगा, रेस्पोंडेंट को पता. बताइए क्या है? अपील तो डिसमिस हो गया, सूट क्या हुआ? पार्टली डिक्रीड हो गया.
Submit paragraph, it has been stated that plaintiffs have purchased a land under plot number 390, 391 and 392 under
तो रजिस्टर्ड सेल डीड का राइट टाइटल इंटरेस्ट पोजीशन सब कंफर्म कर दिया ट्रायल को. अब क्या बचा? रजिस्टर्ड डीड से परचेज किया हुआ प्रॉपर्टी का राइट टाइटल इंटरेस्ट पोजीशन सब कंफर्म कर दिया और उसके अगेंस्ट में अपील डिसमिस कर दी है ना? अपील हैज बीन डिसमिस्ड. Rightly decided title suit has purchased the suit land from the rightful owner and the plaintiffs are the exclusive owners of the suit land. It is held that Sushila Baruin was entitled to transfer the scheduled property to Santosh Bala Dasi through 3 registered sale deeds. इसमें क्या गलती है? बताइए क्या गलती है? कॉन्करेंट है ना?
ये कॉन्करेंट फंडिंग है
और
plaintiff-
संतोषी वाला डासी का वेंडर का टाइटल कंफर्म कर दिया है that she had the right to sell the property.
and therefore we have rightly
Yes.
purchased. It is we are the plaintiff, respondent. They are the defendant, appellant. दो कोर्ट से आ रहे हैं. The findings of the learned appellate court also is the same line, affirming the judgment of the learned trial.
संतोष वाला दासी का पोजीशन भी था, म्यूटेशन भी था, सभी तो
वो
था.
हमको बेचे हैं राइट.
ये डिफेंडेंट का क्या केस था?
डिफेंडेंट का केस है कि सी हैज गॉट नो राइट टू सेल.
राइट किसको था?
उनका जो
After
अपना
remarriage-
केस है पैराग्राफ 3 में.
After remarriage, she had no right to sell.
Yes, but according to the defendant, Lord, that the entire property of Khata number 05 was named in the name of Mohri Bawri as inherited, and after death of Sambhu Bawri, his widow Susila Bawri remained with Gonku Bihari village Asra. That could not be proved. Susila Bawri never possessed the land. These are the case of the
तो
defendant.
उनका सुशीला बावरी का रिमैरिज हुआ, ऐसा प्रूव हुआ?
नहीं.
नहीं हुआ ना proof?
इसीलिए तो हुजूर उनका माना गया कि she has got the title.
Right.
Finding of facts are concurrent finding by both the land and courts, and issue number 5 and 6. Those are the main issue. Whether Susila Bawri was the legally married with Sambhu Bawri, and being a sole successor of Sambhu Bawri, she rightly transferred his scheduled property to one Santosh Wala Dasi through valid registered sale deed dated
Your possession has been confirmed.
confirmed, and title has also been confirmed.
अब इनको टाइम चाहिए, क्या ही बोले? बताइए कब करिएगा? बोले थे कि कभी भी कर देंगे, तो आप आज कल के लिए तैयार नहीं है. कभी में कल इंक्लूड नहीं. बताइए. वेडनेसडे. ठीक है? लिखिए. essay number 217 of 2020. Learned Counsel for the appellant prays for time. The Learned Counsel for the respondents have entered appearance by filing a caveat. The Learned Counsel for the respondents, while referring to the impugned judgments, has submitted that the case of the defendant was that Sushila Bowring had remarried after the death of her husband, and therefore she had, after the death of her husband Sambhu Bawri, and therefore she had no right to transfer the property to Santosh Bala Dasi, who was the vendor of the plaintiffs. The plaintiffs had purchased the suit property by registered sale deed from Santosh Bala Dasi. He has submitted that the defendants could not prove that Sushila Baroin had remarried. He has also submitted that there are two concurrent findings with regard to right, title, interest and possession of the suit property which the plaintiff had purchased through registered deed. Since the counsel for the appellant is seeking adjournment on account of personal ground of the arguing counsel of advocate on record. आप अपना नाम बताइए.
अजीत कुमार सिंह.
Ajit Kumar Singh. Advocate on record, Mr. Gaurav Kumar, And at his request, the matter is directed to be listed on next Wednesday to be posted in the supplementary consultation. To be taken up as first case.
Item 8, second April 67 of 2021.
Yes.
मिस्टर केसी महतो आदमी जिस केस में उनका तबीयत खराब है जाया नहीं है नेक्स्ट वीक
हाईकोर्ट का तबीयत खराब हो गया है क्या?
नेक्स्ट
फर्स्ट अपील सेकंड अपील सुनते ही सबका तबीयत कैसे खराब हो जाता है?
नेक्स्ट वीक में
नेक्स्ट वीक ऐसा तबीयत मत खराब करिए, सबको हॉस्पिटल पहुंचा दीजिए। मिस्टर सानी, सबका तबीयत खराब हो गया है, हम क्या बताएं? हर एक काउंसिल का तबीयत खराब हो गया है। जिसका केस कॉल आउट करते हैं तबीयत खराब, मतलब कोर्ट ठीक नहीं चल रहा।
कोर्ट देखिएगा हर केस में 1000, 2000, 4000, 8000 तक हुआ, 32,000 का भी हम जानते हैं। हम नहीं दिए।
यहाँ पे अब ऐसा नहीं होगा, यहाँ पे तो हम सुनेंगे ही।
नेक्स्ट वीक में एनी डे, नेक्स्ट वीक एनी डे।
आपके पास फाइल है ना?
नहीं फाइल भी नहीं, फाइल रहते तो हम जो भी होता है कर देते हैं, क्योंकि
देखिए 2000 रुपए आपको फाइन हो
चुका है मेरा, इसलिए हम
उसके बाद 1000 रुपए भी हो चुका है।
हाँ,
अभी हम 5000 रुपए किए हैं कि एडवांस नोटिस नहीं।
नेक्स्ट वीक एनी डे कर दीजिए मैडम, हम कर लेंगे।
उनका भी नेक्स्ट वीक एनी डे ही किया,
लेकिन
कैसे होगा?
गरीब आदमी कर दीजिए, हम
गरीब को और गरीब मत बनाइए, फाइन लगा दो।
इसलिए विजिट बोलते
64,000 तक हम सुने।
नेक्स्ट वीक कर दीजिए, विजिट कर देंगे।
एडवोकेट जनरल का ऑफिस का 64,000 सुने, हम रेस्पोंडेंट इसलिए अपने
ऐसे एडजमेंट नहीं होगा।
तो टुमारो रख दीजिए।
ये कोर्ट नंबर 11 फाइल तो पढ़ के आते हैं और बहुत टाइम लगता है, स्लो कोर्ट
ये
है,
हम
समझ
लोग
में बहुत देरी से आता है।
टुमारो रख दीजिए।
हम लोग ने बहुत सुविधा है, पढ़ के आते हैं इसलिए उसको बोलने में
कॉस्ट नहीं किया जाए, टुमारो रख दीजिए, टुमारो कर लेंगे।
क्या ही करें बताइए, हम तो समझ ही नहीं आता। जजमेंट ऑफ एफर्मेशन है,
इसलिए मुझे बोल रहे हैं कि नहीं टुमारो रख दीजिए, टुमारो ही कर लेंगे, फाइल आज शाम को ले लेंगे।
बिना कॉस्ट के हम एडजर्न नहीं करेंगे।
नहीं टुमारो कर दीजिए।
हाँ टुमारो करने के लिए भी तो कॉस्ट लगेगा ना।
कॉस्ट नहीं दे पाएगा मतलब, इसलिए
नहीं दे पाएगा तो डीएफडी हो जाएगा, फिर क्या है? 2 बार दे चुके हैं ना,
2 बार दे चुके हैं,
1000 रुपए दिए
वो हम अपना पॉकेट से दिए हुए, इसलिए बोल रहे कि नहीं मत कीजिए उसके साथ।
एडवोकेट के ग्राउंड में टाइम होगा तो एडवोकेट को पॉकेट से ही देना पड़ता है।
इसलिए टुमारो रख दीजिए, टुमारो कर
कोई
लेंगे।
डीएफडी होने के बाद फाइल रेस्टोर कराने के लिए आज तक कोई क्लाइंट पैसा दिया है? नहीं देता है ना, फिर वो सारा वकील साहब को देना।
इसको पार्ट हट कर दिए।
पार्ट हट बिना सुने ऐसे आप रिकॉर्डेड प्रोसीडिंग में पार्ट हट कर देंगे, आपको क्या लगता है?
फाइल भी नहीं तो हम कर देते हैं, कॉन्काइंड फाइंड है जो भी होगा।
The learned counsel for the appellant, Mr. नाम बताइए, अक्षय कुमार महतो, seeks adjournment by submitting that the arguing counsel, Mr. H.K. Mahto, K.C. Mahto is not well. He submits that the matter be posted in the next week. In case the arguing counsel is not available, he shall argue the case himself. Post on Wednesday.
short possible in item number 10, 11, 12.
कॉल होने दीजिए ऑन करेंगे आगे
For hearing item 10, second case 381 of 2017.
yes who will argue this case
Mr. Sanjay Kumar Tiwari.
फाइल है ना आपके पास
No, Lord, sir.
नहीं फाइल भी अपने साथ रखे हैं आपके सीनियर
No, Lord, sir, for item number 10, concerned advocate has become state counsel, and the letter regarding this has been.
स्टेट काउंसिल होने से क्या हो गया
But
सेकेंड अपील में
state is also party also.
स्टेट इज अ पार्टी
Yes, Lord, sir. And regarding this letter has been given to the concerned party.
ऐसे नहीं होगा ना इस तरह से यू हैव योर रिस्पॉन्सिबिलिटी यू जस्ट कांट डू इट लाइक दिस 2017 का केस है स्टेट काउंसिल तो बहुत पहले ही बनाया है संजय कुमार ने
Yes, sir. But no response has been given to us by the applicants. So we have
डीएटी कर देते हैं रिस्टोर होगा जब होगा क्या है?
let us say short possible.
ठीक है बुलाइए उनको
नेक्स्ट वीक के लिए
क्या चीज
नेक्स्ट वीक के लिए हम अप्लाई करेंगे
पहला केस हियरिंग का आप बताइए कौन सा हियरिंग का केस हम कर लें
मिस्टर सीनियर
दूसरा केस तैयार कर दीजिए हम आपको टाइम देंगे
इसमें सीनियर ने केस करेंगे
तो क्या काम करें
किसी सरकार के सोकर
नहीं
इसमें रेडी
ऐसे
सीनियर को
नहीं
इंगेज करना है
अभी वो पास ओवर मांग रहे हैं आप रुक जाइए
Item 11, second case 390 of 2017.
Same.
सेम पे इसको भी पास ओवर इनको बोलिए आने के लिए नहीं तो उठते उठते डीएफडी कर देंगे इनको बुलाइए जल्दी से
Item 12, second case 234 of
12
2018.
सब सेम मैटर है क्या
No,
फिर
नहीं के द्वारा आर्ग्यू किया जाएगा.
इसका क्या मतलब है आपको सिर्फ टाइम लेने के लिए आने
No, no, no.
आप रेस्पोंडेंट हैं अपीलांट कहाँ है उनको पहले से कवर कर देंगे
No, no, no.
फिर सीरियल नंबर कौन सा है
12. उनको कवर नहीं किया. Item 12.
मनोज कुमार चौबे कहाँ है वो? आप तो इसमें स्टेट की तरफ से होंगे ना
No,
संजय कुमार तिवारी इज अपीयरिंग फॉर प्राइवेट रिस्पोंडेंट
Yes, Lordship. For Ramjanam Yadav.
राम जन्म यादव इसमें तो स्टेट पार्टी नहीं है
No,
फिर इसमें क्या दिक्कत है?
ma'am, he's in court number 8. Lordship.
ठीक चलिए नेक्स्ट केस
Item 13, second appeal 254 of 2018.
सेकंड अपील
254 of 2018. Item 13.
स्टे विकेटिंग इंटरिम रिलीफ इंजंक्शन सब ऐसे बताइए
कुछ भी आइए पेंडिंग है आइए नंबर 5244 और 23 और एडिशनल सब्सटेंशियल क्वेश्चन
ठीक है वो तो सुन के ही ना पता चलेगा चलिए बस करिए
Plaintiffs have filed suit for eviction against the defendants on the ground of personal necessity and default in payment of rent. However, Lordship, before the sale, the defendant, they applied before your ladyship.
कौन सा आई पेंडिंग है आपका आइए नंबर
5244 और 23 Lordship.
फाइव टू फोर वन ऑफ 23
5244 filed on 16/6/23.
ये तो ग्रांट ऑफ इंटरिम रिलीफ है, जिसमें
नहीं,
लिखा
वो दूसरा है।
What do you say to this question of law?
This kind of framework.
Yes, Exhibit 2 was marked with objection after institution of the suit. After institution
Yes,
of
sir.
the suit का ही तो
जी,
exhibit होगा,
जी,
इस सूट के साथ ही exhibit सब करना है.
सूट के साथ ही वाला लॉर्डशिप, बट एग्जिबिट 2 जो है वो दूसरे सूट का ऑर्डर सर्टिफाइड कॉपी है लॉर्डशिप. दैट सूट इज स्टिल पेंडिंग.
General power of attorney holder dated 12/3/2013. ये क्या question of law बना है?
नहीं नहीं, apology lordship, that is with regard to general power of attorney. The plaintiff has not been examined in this case.
Okay.
And in place of the plaintiff, the power of attorney has deposed. And that is barred by the law lordship. In that regard, I would like to provide some judgments.
Personal knowledge होगा तब नहीं होगा एग्जाम में. Otherwise,
Lordship, in this section 11C lordship में आ रही है the Bihar Building Land Reforms Rent Control and Eviction Act lordship.
11C BBC Act है. क्या बोलते हैं?
The building is reasonably and in good faith required by the landlord for his own occupation or for occupation of any person for whose benefit the building is held by the landlord, provided that where the court thinks that the reasonable requirement of such occupation will be substantially satisfied by electing the tenant for part of that building and allowing the tenant to continue in operation. And the tenant agrees to such occupation, the court shall pass decree accordingly. While lordship, in this the landlord has to be compulsorily examined before the court.
कहाँ लिखा है?
Your lordship, there are two grounds on which eviction was sought, your lordship. One is areas of rent, your lordship. More than 2 months' rent has admittedly not been paid, and also for personal necessity, your lordship. Also, there was a question of law framed regarding
Decree was for personal necessity.
Both, your lordship.
For both.
For rent also. Your lordship, they have admittedly not paid the rent, your lordship, because they had denied the relationship between the landlord and tenant. That is why the personal witness or the necessity of the plaintiff to come to the witness box was not necessary, your lordship, in this case.
They have not denied the relationship of landlord.
They have denied, your lordship. They said that a sale deed by the predecessor in interest had already been executed in their favor.
And they were already in
Yes,
possession
yes,
of the
your lordship.
property, and therefore they ceased to be the tenant.
Yes, your lordship. That is why personal necessity was one of the ground, but areas of rent also was another ground on which the eviction was sought, your lordship. And it was proved, and the relationship also was proved, your lordship. And that is why the witness had deposed through a power of attorney. The power of attorney holder had deposed on her behalf, Your Lordship. That is why in this case, the necessity of the plaintiff to come to the witness box was not.
He is
required.
relying upon some judgment. What is it? Where does it say that the power of attorney cannot depose?
Para 13 onwards.
Read para 13.
Para 13. It is settled legal. You should found it. It is a settled legal proposition of law that a power of attorney holder cannot depose in place of the principal. Provisions of Order 3, Rules 1 and 2 of CPC empower the power of attorney holder to act on behalf of the principal. The word acts employed therein is confined only to acts done by the power of attorney holder in exercise of the power granted to him by virtue of the instrument. The terms act would not include deposing in place of and instead of the principal. In other words, if the power of attorney has preferred any acts in pursuance of the power of attorney, he may depose for the principal in respect of such acts, but he cannot depose for the principal for acts done by the principal and not by him. Similarly, he cannot depose for the principal in respect of a matter as regards which only the principal have personal knowledge and in respect to which the principal is entitled to be cross-examined. Then para 14, Ladyship. So this will now pertain to the facts of this case. And with regard to our claim, it is based on agreement to sale followed by possession. We were already in possession. The court below has said that although there was an agreement to
Registered agreement.
Unregistered agreement, but we were in possession with respect to that the tenancy that was earlier between the original landlord and the tenant. Thereafter, we stepped into the shoes of prospect purchaser. So the tenant of landlord, the relationship of landlord and tenant.
So landlord could not have deposed through power of attorney.
Yes, Your Lordship.
It was the landlord who deposed from
Yes,
through
Your
power
Lordship.
of attorney.
The subsequent purchasers, they are claiming on the basis of sale of 2008.
Who deposed through power of attorney? The landlord, the tenant.
The landlord.
The landlord, he deposed through power of attorney.
Yes, Your Lordship.
Your Lordship, there's a
We'll include it as a point of law.
Your Lordship, there's a finding on that point, Your Lordship, by the appellate court also.
We'll see.
Your Lordship.
The appellate court has recorded a finding.
Yes, Your Lordship.
What about the trial court?
The trial court also has given the same finding, Your Lordship. It's a contempt order, Your Lordship. Nothing of that sort has been deposed regarding which she had any personal knowledge, Your Lordship.
Let us see the finding. If there is concurrent finding that there is no requirement of cross-examination on the basis of any personal knowledge, then we will not allow this as a substantial question.
Yes.
Right? Let us see the finding of both the courts. Was any issue framed to that effect?
No issue.
Any objection raised and decided? Where is the finding of the appellate court with regard to this point?
This is the last paragraph. Your Lordship, internal page 15 of the appellate court
Yes.
order, Your Lordship.
Yes.
If I may read from para 14, Your Lordship.
Yes, please read.
Incidental to the question of personal necessity is the question of partial eviction. The law is settled that where apart from the ground of personal necessity, if there is any additional ground for eviction, then the question of partial eviction pales into insignificance. In this case, there is a ground for eviction on account of default in payment of rent. Apart from that, the finding of the court below on the point of partial eviction is also in accordance with law and does not require any interference. Argument on behalf of appellant, plaintiff, that respondent was not examined in person is also of no use. The law is settled that non-examination of plaintiff in person will be fatal if evidence is to be given in respect of facts to the personal knowledge of plaintiff. In this case, the entire suit is dependent on the documentary evidence and the admission of the defendants. Hence, non-examination of the plaintiff in person and examination of the power of attorney holder on behalf of the plaintiff is not a defect which goes to the root of the case.
Lordship, in this regard, the judgment that I have cited is very much clear. That he has to depose only on behalf of the acts that he has done. That does not include deposing in front of the court, Lordship. And it has nowhere been mentioned that these were done in the consciousness of this power of attorney holder.
Lordship,
What is the date of power of attorney? Which act was not done by the power of attorney and was done by the land? Which act?
Since they are claiming on the basis of deed, sale deed, that sale deed was not executed by any power of attorney holder.
Unregistered sale deed.
No, their sale deed is registered. Our agreement to sale is unregistered. That was covered with delivery of possession. Since we were
Agreement of sale is by the power of attorney?
No, Lordship. The original vendor of the defendants and our original landlord.
And what about the trial court?
Trial court, there was no issue claimed in this regard.
Your Lordship, I can read the extract of the evidence of PW1.
What is the name of the original landlord? Govind Kumar.
Kanta Jain. No, original is the predecessor in interest to the plaintiff, Your Lordship.
Who is the original landlord?
Govind Badhani and Sandhya Badhani, Your Lordship.
Govind Kumar and Sandhya Badhani.
Yes, Your Lordship. The plaintiff had purchased the land from them.
The learned counsel for the appellant has submitted that IA number 3449.
5244.
5244 or 23 has been filed to include the following substantial question of law for decision in this case. Inverted comma. Whether the evidence led by the general power of attorney holder dated 12/3/2013 within bracket exhibit 2 bracket close bracket marked with objection bracket close comma after institution of the suit could have been looked into by both the courts below for incidents/facts happened prior to institution of the suit. The learned counsel for the appellant has submitted that in the present case, PW1 was the constituted attorney of the original landlord. Original landlord?
Subsequent purchaser.
But we are claiming to the landlord and his own
Of the subsequent purchaser, although the original landlord was
Govind
Kumar and Sandhya Badhani. Okay. He submits that there is no absolute bar in examination of constituted attorney as witness, but in the circumstances where, but he cannot depose for the principal for the acts done by the principal and which were not done by him. And he can also not depose in connection with the personal knowledge of the principal. The learned counsel submits that in the present case, he has deposed on the basis of he has deposed by referring to the acts done by the previous landlord and therefore the aforesaid substantial question of law arises for consideration by this court. The learned counsel for the appellant has referred to the appellate court's judgment and has submitted that this aspect of the matter has been taken care of, and it has been held that non-examination of the plaintiff in person and examination of the power of attorney on behalf of the plaintiff was not a defect which goes to the root of the case. However, so far as trial court is concerned, no such finding has been recorded. Correct? No finding?
There
There are no issues framed in this report.
no objection had been made during the trial stage.
Issue number 5 deals with this aspect.
Yes, yes, it is there. She has also submitted that this aspect of the matter has also been considered under issue number 6, I think.
Page 27, running page 35, issue number 5. Under that heading, they have read with it. It has been specifically argued that the plaintiff has not been examined as a witness in the suit, and the major part of
Para
the
number?
Para 6, page 35, running page 35.
Para 6, आपका internal page बताइए.
Internal page 27. Internal page
Internal page
Trial court का
seven,
बताइए.
seven.
judgment, Your Lordship, where the findings start.
आप देखिए ना इंटरनल पेज 18 ऑफ द ट्रायल कोर्ट 8.6. Right? This point has been rejected. And no adverse inference can be drawn due to non-examination of the landlord plaintiff, and the suit cannot fail on this ground. She has also referred to paragraph 8.7 of the trial court judgment and has submitted that the learned trial court has held that, has also held that non-examination of plaintiff in the eviction suit is not bad in law. She submits that both the courts have given concurrent findings in connection with the consequence of non-examination of the plaintiff, and no question of law as sought to be introduced to the interlocutory application arises for consideration in this case. यही है? After going through the impugned judgments and findings recorded by both the courts in connection with non-examination of the plaintiff in person and examination of the power of attorney. This court does not find any reason to include the
Leadership, just one more thing, Leadership.
additional question of law as sought to be introduced through the interlocutory application for consideration in the second according to the case hereby rejected.
Leadership, may I submit one thing? The power of attorney is dated 12/3/13. Sale deed is executed way back in 2008. And
That is not the question of law that you have framed in your interlocutory
Leadership, that is what I
application.
am bringing to your leadership
कुछ नहीं,
knowledge.
आप मेरिट पे आइए ना, क्या ही करना है आपको? बताइए कब करिए, कब आर्ग्यू करेंगे बताएं?
Any convenient date, your leadership.
Today is the most convenient day.
Senior will be arguing in this
Who is
case.
the senior?
Mr. Manjul Prashant.
तो शुरू तो करिए ना, आप तो अच्छा बहस करते हैं, आपको तो सब लॉ पता है. उनको कंक्लूडिंग रिमार्क्स आप शुरू. Yes, है ना? Seniors are to give concluding remarks to ensure that their appearance is recorded. Correct? उनके आए बिना तो हम नहीं रिकॉर्ड करेंगे appearance. चल, शुरू हो जाइए.
Lordship, the plaintiffs had brought suit for eviction on the ground of non-payment, default in payment of rent. In that regard, we have already stated that we entered into an agreement and we were in possession of that.
ऐसा नहीं होगा, आप थोड़ा सा admitted case है ना?
Yes, sir.
पहले substantial question of law देखो.
Order number 4, your leadership.
चलिए. पढ़िए.
Whether the impugned judgment and decree passed by the learned courts below stand vitiated for not taking into account the pleadings of the parties, which clearly established that during the subsistence of the tenancy, the plaintiff landlord had executed an agreement to sale dated 22/2/2006 in favor of tenant defendant, and as such, since the relationship of landlord and tenant ceased, hence the suit for eviction of tenant itself is not maintainable.
What is the date of sale deed executed by the landlord in favor of the tenant? What is the name of the original landlord? Kindly give the name once again.
Govind Badani and Sandhya Badani. Govind Kumar and Sandhya Badani.
Govind Kumar and
Sandhya Badani.
yes.
Registered sale deed number
Registered sale deed number
1379.
1379 dated
8/2/2008.
8/2/2008. They transferred it to
Transferred to Kanta Jain.
Kanta Jain. Respondent.
Yes, sir.
Okay. Now you tell us that after 8/2/2008, is there any evidence regarding payment of rent to Kanta Jain?
No, yes,
Okay. So far as the tenant is concerned, he paid rent to the original landlord till when?
2006.
Date.
Date has not come on court, your lordship, but till the time they were allegedly entered.
22/2/2006. That is the date of agreement.
22/2/2006, and thereafter you stopped paying rent.
Yes, sir. It's because the landlord-tenant relationship came to an end.
That ceased, according to you. Okay. Now you tell us that who filed the suit? Kanta Jain.
That is
For recovery of possession.
For, yes, your lordship, eviction, recovery of possession, lordship.
For eviction. Suit filed by Kanta Jain for eviction on ground of
default in payment of rent and for personal necessity.
default and personal necessity.
And we had filed a suit for specific performance of that agreement also.
That is pending.
That is still pending.
Specific performance suit is pending.
Yes, sir. That is still pending. Title suit 20 of 2007.
What is the stage?
Leadership, recently we had filed an application for amendment in the claim. Opposite parties had filed rejoinder. It is still pending for disposal.
This title suit was filed prior to the sale deed executed in favor of the
Yes, Your Ladyship. And prior to institution of this suit also.
and prior to institution of this suit also. This second appeal should not be decided unless this title
Yes, Your
suit is
Ladyship.
decided.
And the courts below should not have ordered for eviction, Your Ladyship.
That we do not know, but we will not decide this second appeal unless this title suit is decided. They have filed a suit for specific performance.
In the stage of amendment, Your Lordship.
We do not know. Okay, let us see. यहाँ से स्टे है तो स्पेसिफिक परफॉर्मेंस अपना मूव भी नहीं करेंगे.
Lordship, they are appearing rejoinder भी डाला हुआ है जैसे ही
अच्छा कोई बात नहीं, आप थोड़ा सा और बहस करें.
Because that is against my predecessor in interest, Your Lordship. I have already purchased the land. I am the one
That
suffering.
predecessor in interest has lost the title.
That is the main point of.
And specific performance successor in interest पर नहीं हो सकता.
Exactly.
नहीं हो
We
सकता
are
है ना?
claiming to be the owners in that suit also that they have to continue with the performance of the agreement.
So therefore, if the person who has entered into the agreement passes the title to somebody else, then you have to pray for cancellation of deed.
Leadership, but we were in possession also with regard to.
That's
Section
right. Then
53A.
you have to pray for cancellation of that particular subsequent deed.
So that will be subject to the outcome of original suit
No,
20,
no, no.
2007.
That is not the.
Once a claim is defeated over there in 2007, 2007, automatically they will succeed in this case. We having been lost as prospect
Your Lordship,
purchase.
also one more thing, even after executing the sale, Your Lordship,
चलिए हम लोग इसी को decide.
they had paid rent, Your Lordship, to the predecessor in interest, Your Lordship, and this point also was taken into consideration by the appellate court, Your Lordship.
That is why. Let us see that. Suit for specific performance is pending anyways. Okay. This eviction for default and personal necessity. Default was from which period?
22 to 2006.
22 to 2006. Till the date of filing the suit.
This is what we are saying that from 22 to 2006 it has not been paid.
We have claimed that we had purchased the suit on 8th February 2008, Your Lordship, and it has been very well informed to them that it has been purchased, Your Lordship, that the landlord has been changed, Your Lordship, and after that till 2 months they had not paid the rent. So basically from 8th April 2008 the default has started.
Suit was disposed of list pendants of
Default
20
is from 8th February 2008. The cause of action was arose from 8th April 2008.
application, what the appellate court has done, the appellate court has come to a finding that since it was unregistered document, so it becomes non-est in the eyes of law with regard to delivery of possession. Since the delivery of possession cannot be acted upon based on an unregistered document. But the court below has failed to take into consideration that we were already in possession. The possession was already delivered by the original landlord to us.
The power of attorney was a lady. She was a lady. You just come to page number 28, internal page 8 of the suit. Last line. Last line. Internal page 8 of the eviction suit, last line. She has further deposed that after the said purchase, the plaintiff as well as the previous landlord had given information to the defendant about the sale. So this power of attorney comes into picture after the sale. And she is deposing that the previous landlord had given information. ये तो substantial question of law को admit करना. वो तो order change करिए तो. You have taken the dictation. The learned counsel for the appellant has also submitted that PW1 had deposed that that after the purchase, the plaintiff as well as the previous landlord had given information to the defendants about the sale. He submits that this was essentially arising out of the personal knowledge of the landlord, and this could not have been deposed by the power of attorney. He submits that the consequence of such deposition of the power of attorney has to be considered in the light of the evidence of the power of attorney and its consequence in the eviction suit. Considering the, just a moment, facts and circumstances of this case, this court finds that the aforesaid question of law does arise for consideration in this case, and accordingly the IA number such and such is allowed. सुन लेंगे ना क्या है दिक्कत?
That is not problem also, Your Lordship. This information would not matter at all because they are.
We will see that. We will see the consequence.
Because they are saying that the relationship of landlord
We
and
will
tenant
see
has
that.
already ceased.
We will see that. The counsel for the respondent has submitted that this information has no material impact
Since they had
in the findings of the court. That's it. We will see that. We will see
Just
that.
one more line. Since they had already said that they have the relationship between the landlord and tenant has also ceased between them and my predecessor in interest since 2006 only. Since they had entered into an agreement with them.
Deposition
That's
cannot be an estoppel against law.
चलिए पढ़िए पढ़िए. Read this trial court judgment and the finding.
Page 8 में ले लीजिए.
वो ये allowed है ना, ध्यान दें. that IA stands allowed. So the
Same
page
paragraph.
number. What are the findings? The issues. Let us see the issues.
You should start at page 5.
Yes.
Whether the suit is maintainable in its present form for the release claim, whether the plaintiff has got valid cause of action for bringing the suit, whether the suit is not maintainable being undervalued, whether the suit is barred by limitation, principle of estoppel, waiver, acquiescence, and JBC Act and Specific Relief Act, TPI, Contract Act, CPC. Whether there exists a relationship of landlord and tenant.
This issue is important.
Yes, Your Lordship.
Okay. What else?
Whether the plaintiff requires the suit premises bona fidely and in good faith. And
Is it important?
In the appellate court, it will be important, Your Ladyship, because the
No,
appellate
but
court.
considering the question of law, is it important? No, it's not important. What is important is Roman 5 only. Partial eviction, etc. is not important. Correct?
Yes, Your Lordship.
Okay, now let us see Roman
And
5
issue number
findings.
8 also, Your Ladyship.
Issue number 8.
Whether the defendants defaulted in payment of rent for more than 2 months and thereby made themselves liable for eviction. That will be related to
You
issue
see-
number issue 8. That will be related to issue 5 itself. Whether the defendants defaulted in payment of rent for more than 2 months and thereby made themselves liable for eviction of the suit premises.
Okay. Alright. 5 and
5 and 8.
8. Let us see the finding with respect to 5.
Issue number 5, page 7. The learned, this being the most important issue in the eviction suit under JBC Act, it is herein taken up for decision thereon. The learned counsel for the defendants in the course of final argument has argued that the plaintiff has been miserably failed to prove that the alleged relationship of landlord and tenant between the parties. No rent receipt tenancy agreement have been filed and proved by the plaintiff. It has been specifically argued that the plaintiff has not been examined as witness in the suit, and a major part of evidence of Peter has constituted a problem of the plaintiff before the court of execution of general power of attorney dated 12/3/13 has absolutely no evidentiary value at all, which is apparent from the decision of the Honorable Supreme Court reported in 2013, so and so, wherein it has been observed that by their lordship that the power of attorney holder cannot depose in a suit as substitute as a principal, but can depose only the facts which she preferred in pursuance to power of attorney, and cannot depose for the acts which the principal herself preferred before the execution of power of attorney. He has further argued that there is no mention of the fact in the claim that since which month the defendants made default in payment of rent. He has further argued that under the settled principle of law, the plaintiff cannot derive any right, title, interest over the suit, as the sale deed of the plaintiff is illegal, void, inoperative, and held by principle of dependence in view of the agreement of sale of the suit premises between the vendor of the plaintiff and the defendants, and for which legal enforcement by specific performance of the contract, a prior suit being title suit 20 of 2007 has been brought by the defendant number 1 against the vendor and purchasers of Exhibit 1, which is pending in the Court of Civil Judge Senior Division 6 at Jamshedpur. As such, the defendants are not tenant under the plaintiff. On the other hand, the learned counsel for the plaintiff during the course of final argument has argued that the plaintiff is the owner of the suit premises which he has purchased from the original landlord of the defendants, and after the purchase of the suit premises on 8/12/2008, the plaintiff stepped into the shoes of original landlord, and as such, the plaintiff has become the landlord of the defendants since 8/2/2008. He has further argued that the atonement is not condition precedent for creating a relationship of landlord and tenant between the transferee of the landlord and the lessee transferor. Transfer takes place with all incidents of right, title, and interest of the lessor, and the transferee is entitled to sue the existing tenant for eviction under the Act, even if the tenant is not attorned to his tenancy under him. Atonement of tenant is also not essential to the validity to the transfer made in favor of the transferee. He has further argued that although there may be an agreement for sale between the vendor of the plaintiff and the defendants prior to the transfer of suit premises in favor of the plaintiff, and there may be a suit pending between the vendor of the plaintiff and defendants for specific performance of the contract, but this very fact, even if admitted, cannot help the defendant course in view of Section 11 of JBC Act to deny the relationship of landlord and tenant between the transferee and tenant. In this regard, he has put reliance on the case reported in Swanjo. PW1, who is the constituted power of attorney, has deposed that in his affidavit examination in chief on the point of this issue, that the plaintiff has purchased the suit premises from Govind Kumar and Sandhya Bhadani through registered sale deed dated 8/2/2008. The father of the defendants, namely Vijay Kumar Jain, was the tenant of the said vendors on monthly rent of Rs 150, and after his death, the defendants are in possession of the suit premises as tenant. She has further deposed that after the said purchase, the plaintiff as well as the previous landlord had given information to the defendants about the said sale. She at para 22 of the cross-examination deposed that defendants are tenant of the suit premises since 8/2/2008 at the rate of monthly rent of Rs 150. At para 23, she has deposed that the tenancy was given orally and no rent receipt was given to the defendants. At para 25, she has deposed that the father of the plaintiff, namely Vijay Kumar Jain, has been running a shop in the suit premises since 50 years. But these were all of PW1, power of attorney.
That's right.
PW2 is a formal witness, he has deposed nothing on the point of this issue. PW3, who is an independent witness, has deposed in his affidavit examination in chief on the point of this issue that Govind Bhadani and his wife Sandhya Bhadani had sold the suit premises in favor of the plaintiff on 8/2/2008. The father of defendants, namely Vijay Kumar Jain, was the tenant on the said suit premises, and after his death, the defendants have been possessing the same as a tenant on a monthly rent of Rs 150. He at para 11 of his cross-examination deposed that he has not read the plain and written statement of the suit, and at para 12 he has deposed that he cannot say the description of the suit premises. DW1, who is one of the defendants of the suit, has deposed in his affidavit examination in chief on the point of this issue that the suit premises was given to his father Vijay Kumar Jain on a monthly rent by said Govind Kumar and Sandhya Bhadani, and the plaintiff is not the landlord of the defendant. There exists no relationship of landlord and tenant between the parties, as still the owner of the suit premises is Govind Kumar and Sandhya Bhadani. He has further deposed that the plaintiff has neither informed with them about the purchase of the suit premises nor she has ever claimed the rent of the suit premises from them. He has further deposed that on 22/2006 an agreement for sale of the suit premises has been executed between him and Manju Jain at one side and Govind Kumar and Sandhya Bhadani on the other side. And out of the total consideration amount of Rs 31 lakhs, Rs 5 lakhs was paid to the vendor or the plaintiff and issued a money receipt thereof. He has proved the notarized agreement for sale dated 24/2/2006 and the same has been marked as Exhibit A in the suit. He has further deposed that he and Manju Jain were ready to perform their part as per agreement for sale, but the vendor of the plaintiff has not executed the sale deed. Thereafter, he has filed title suit 20/2007. But during the pendency of the said suit, the vendor of the plaintiff has illegally sold the suit premises to the plaintiff and Abhilasha Jain, PW1. However, at para 25 of the cross-examination, he has admitted that his father was a tenant in the suit premises and after his death, they become the tenant therein. At para 26, he has deposed that they have been paying rent to the vendor of the plaintiff at the rate of Rs 150 per month. At para 29, he has deposed that after getting information on the sale of the suit premises, he has made the purchases, namely the plaintiff and Abhilasha Jain as party in the said suit. Title suit 20/2007 on 26/3/2008. At para 38 of his cross-examination, he has admitted that the disputed premises has been shown in the sale deed of Kanta Jain, which is a part of her land. DW2 in his affidavit examination and chief on the point of this issue has deposed that there is no relationship of landlord and tenant between the parties and the plaintiff, despite having knowledge of agreement of sale as Exhibit A and the title suit 20/2007 has fraudulently purchased the suit premises. He has further deposed that the said vendor of the plaintiff has received Rs 5 lakhs as advance from Rajesh Jain and Manju Jain as advance money from the purchase of the suit premises and agreed to pay rest consideration of amount of Rs 26 lakhs as per agreement for sale, but they had not executed the same as per the agreement. However, at para 22 of the cross-examination, he has admitted that the defendants are tenants in the suit premises. At para 13, he has admitted that the plaintiff had purchased the suit premises from the said Govind Kumar Bhadani. DW3 is a formal witness on different cause. On the basis of pleadings and evidence adduced on behalf of both the parties, I find that it is an admitted fact of the suit that the suit premises was originally owned by the vendor, original landlord, plaintiff, and the defendant's father, Vijay Kumar Jain, was inducted as a tenant in the suit premises, and after his death, the defendants have been in possession of the suit premises. The plaintiff's case is that she had purchased the suit land from the aforesaid original landlord on 8/2/2008, and thereafter she stepped in the shoe of original landlord and became the landlord of the defendants from 8/2/2008. That is from the date of sale purchase of the suit premises. However, the defendants had denied the relationship of landlord and tenant between the parties and challenged the right, title, and interest of the plaintiff on the ground that the father, Vijay Kumar Jain, was a lawful tenant and the previous landlord, Govind Kumar and Sandhya Badani, and the sale deed executed in favor of the plaintiff is illegal and void, and the same was executed during lis pendens of the title suit 20/2007 between the defendants and the original said landlord in contravention of section 52 of the TP Act. As an agreement of sale between the original landlord Govind Kumar and Sandhya Badani on one side and the defendant Rajesh Kumar Jain and Manju Jain on the other side. There is also dispute between the parties as the plaintiff has averred that the defendants were duly informed by the ex-landlord as well as by the plaintiff about the transfer of the suit premises in favor of the plaintiff. However, it is relevant to mention here that the defendant in his pleadings has given evasive reply to the aforesaid arguments of the plaintiff, and he has only averred that no question of such information arises because there is a previous suit and sub judice in the court as title suit 20 of 2007 between the defendants and the original landlord Govind Kumar and Sandhya Badani for specific performance of contract. Exhibit A and B, which are agreement of sale dated 22/2006 and money received thereof, indicate that there was notarized agreement of sale between for the suit premises between the original landlord and vendor of the plaintiff and the defendant Rajesh Kumar Jain and Manju Jain for sale of the suit premises. It was agreed to sell the suit premises for total consideration of rupees 31 lakhs. And in pursuance to it, the second party, such that defendant Rajesh Kumar Jain and Manju Jain had paid rupees 5 lakh to the original landlord, vendor of the plaintiff, and the rest 26 lakhs was agreed to be paid within 70 days. Now it is to be seen that if the property is sold during the lis pendens of a case for specific performance of a contract regarding the same property, whereas the purchaser stepped into the shoes of the owner of the landlord under the purview of definition of the landlord under Building Act, and the tenant, the original owner, would be treated as a tenant for the said purpose or not. The plaintiff has filed the case under section 11 of the JBC Act, subsection 1 of section 11 of the said Act, start non-obstanding clause that notwithstanding anything contained and any contract of the law to the contrary, where the tenant is in possession of any building, he shall not be liable to eviction therefrom except in execution of decree passed by the court. Hence, this section has overriding effect on Transfer of Property Act and the Contract Act. Section opens with the word notwithstanding anything, notwithstanding any contract, and therefore any contract as per TP Act regarding sale will have no effect in the case filed under section 11 of the JBC Act. It is settled law that the agreement to sell has no relevance with the eviction suit, particularly in the case when the defendants have admittedly filed suit for specific performance. It is also settled law that atonement is not a condition precedent for creating a relationship of landlord and tenant between the transferee of the landlord and the lessee. Transfer takes place with all incidents of right, title, and interest of the lessor, and the transferee is entitled to sue the existing tenant for eviction under the provision of JB Act, even if the tenant has not atoned to his tenancy under him. Atonement of tenant is also not essential to give validity to the transfer made in favor of the transferee. Moreover, I do find any specific pleadings to show that defendants were unaware of the sale purchase of the suit land, as well as the defendant has himself admitted in para 29 of his cross-examination that after the information regarding sale of the suit premises on 8/2008, he has made plaintiff and another purchasers, namely Abhilasha Jain, party in title suit 20 of 2007 on 26/3/2008. The question of title in pure eviction suit does not arise. By entering into an agreement of purchase, the defendant cannot become an owner of the premises till the sale deed is executed and the merger of tenancy with ownership is beyond the scope of eviction. The plaintiff, after purchasing the suit premises from the original landlord, stepped into the shoes and became the landlord of the suit premises. Hence, on the basis of the aforesaid discussion, I am of the view that there exists a landlord relationship landlord-tenant relationship between the parties. As such, this issue is decided in favor of the plaintiff and against the defendant.
Issue number 8 is also related.
Issue number 8, the relationship of landlord and tenant.
Yeah, I'm reading it. Just hold it on for a while. Now the point is that by deciding issue number number 8, the court finds that during the proceeding which was pending for specific performance, in that proceeding, the plaintiff of that case, that is the tenant, was informed about the fact that the property has been transferred to the subsequent purchaser. But there is no finding in the entire record that the subsequent purchaser had ever demanded any rent.
No, Lordship, that is their case. They demanded rent, but on which date they demanded that they have not mentioned in the report. And Lordship, this will also amount to pleadings, evidences beyond pleadings, because since the original plaintiff has not been deposed, he has not deposed, he cannot corroborate the evidences that has been brought in the case.
Considering the question of law which has been framed by this court, by virtue of this agreement of sale and putting you in possession, do you become the title owner of the property?
Lordship will become the prospect purchaser. And until the disposal of the specific performance case, I am still a prospect purchaser. That case will decide whether I will be a tenant or I will become a purchaser.
Where have you stated, I've heard you, right? Where have you stated that you asked for rent, and when did you ask for it? What is the evidence? In the suit. First let us see the suit, finding in the suit. Where is that finding?
Can you read from the plaintiff?
Not from the plaint, you have to read it from the judgment. In the plaint also you have stated any specific date given?
Date has not been mentioned, Your Lordship. Date has been mentioned that after the purchase it has been informed to them that the landlord has changed, and after that they have not
No
been
specific
asked.
date?
That agreement date is only mentioned, the information, regarding information. And after that we had requested them on several occasions.
Where is the evidence to that effect?
Regarding the request, Your Lordship. Regarding the request, Your Lordship, we have only deposed the power of attorney holder and also this independent witness, Your Lordship.
Power of attorney holder simply says that the landlord had informed about the sale. Power of attorney holder comes into picture only in 2013
Yes, Your Lordship.
during the pendency of the suit.
Yes, Your Lordship.
So, how will he depose for whatever had transpired prior to 2013? Who will instruct him? And who will cross-examine him on that point?
PW3, Your Lordship, who was an independent witness, he was also cross-examined on the.
Who is PW3?
He's an independent witness.
Independent means what?
No.
Third party.
But he just
He's nobody.
the plaintiff and the defendant. Your Lordship.
He's nobody. He can't have any personal knowledge what is going on between the landlord and the tenant. What has he deposed?
Your Lordship, the default in payment is admitted, Your Lordship.
It is
Default
admitted,
in
but the
payment
point
is
is that whom will he pay the rent? The original landlord did not file the suit, correct? He is not a party in the suit. So the default for the period 2006 till 2008 is erased completely, because you cannot demand that rent. We do not know where. Therefore, we are asking, when did you ask them to pay the
Your
rent?
Lordship, there is a finding that after, Your Lordship, just one line from the appellate court's order, and subsequent purchase paper. that they have also made the payment of rent, Your Lordship, after their sale date, Your Lordship. There's this line in the app.
Where is that? And where is that evidence that they have paid you the rent? Once a tenant is always a tenant. We can't do anything about it. We do not know. Where is that finding that after the purchase also they have recognized you as a tenant, as a landlord, and they have paid you rent? The status of the appellant, whether it is the status of a tenant or whether it's a status of a prospective purchaser, is under serious cloud.
I'm reading internal page number 13, Your Lordship, of the applicant's order, just 2 lines, Your Lordship. Here it would be significant to mention that there is a material on record to show that despite there being an agreement for sale between the original vendor landlord and the defendant appellant continued to remit the rent to the original vendor landlord. This, which amounts to an acknowledgement of landlord-tenant relationship between the parties.
So he was remitting rent to the original landlord
till 2008, Your Lordship.
So what? Because he had no knowledge about it.
After 2008, Your Lordship, we had informed Your Lordship that has been denied that.
Till 2008, where is that finding that he continued to pay rent, and what is the evidence to that effect? Where is it? Does a power of attorney say? Because he is the power of attorney who would depose on behalf of the original landlord. Did he say that the rent was remitted?
No rent was.
Who will say that? After 2006 also? Did he say that after 2006 until 2008 the rent was remitted by the tenant?
Your Lordship, the sale did also had this description, Your Lordship, that there's a suit pending between the original and
So you have taken, if your sale deed had this stipulation that a suit is pending, right? Then under such circumstances, your status is subject to the suit. How can a decree on basis of default can be passed? You are conscious of this, that there is a suit pending for specific performance of contract. You have purchased the property subject to suit. Then how a decree could have been passed for default and consequent eviction? You have to wait till the specific performance of contract. No decree could have been passed. You want to evict him and make the suit infructuous? You want to construct a building multi-story. यही होता है जमशेदपुर का कहानी. जमशेदपुर का हर एक बिल्डिंग का कहानी हम लोग को पता है, right? अब क्या? No instructions is required.
One hearing date will be kept, Your Lordship. Then Your Lordship.
Instructions की कोई जरूरत नहीं है, because case will be decided on the basis of materials on record.
Right, Your Lordship.
There is no need of any
Verifying
instructions.
the status of the other suit also, Your Lordship.
No, it is pending. He has got positive status. That it is pending. इसमें कोई doubt नहीं. Decree हो जाता तो बात ही क्या है? You would have been nowhere. Suppose the decree is passed, right? Then where is the your sale deed? Exhibit?
Exhibit 2, Your Lordship. Exhibit. That's exhibit 1, Your Lordship.
Where is it mentioned about the suit? Symbolic delivery of possession. Correct? Where is it mentioned? Para 5 more?
The same.
Exhibit 1. So it is
As there is tenants in the schedule B immovable property.
8th of February 2008 is the sale deed.
Yes, Your Lordship.
इसका para 5 कहाँ है?
Page number 4, Your Lordship.
1, 2, 3, 4, 5. Yes.
That there is tenants in schedule B of immovable property, the purchaser has been given symbolic delivery of possession of the schedule B of immovable property.
There is tenant.
Regarding the tenant,
This cannot be relied upon since there is nobody to corroborate the evidence.
it's a registered sale.
Even if it is
Then also its content is required to be. Anyways, we are not bothered about it.
The title suit was not a stipulation, Your Lordship. The tenancy.
Tenancy was stipulated. It was mentioned. Now this section 11. And we do not find anything, any evidence that you had informed him that he should pay the rent. Is there any evidence? That evidence, so to the extent it is by DW1, PW1 cannot be relied upon because he had no personal knowledge about it. Where is your evidence that you have informed him? Don't look at the plaint. Where is the evidence?
Even the pleadings of the plaintiffs will also have the same effect then, because they have also not been corroborated by the plaintiff. So the plaint can also not be relied upon.
Not the entire plaint, but we'll see. At least tenancy, etc. is admitted. Whatever is admitted, that can be relied upon, even so far as the evidence of power of attorney is concerned. But so far as it relates to personal knowledge, that will not be relied upon. That cannot be accepted. Default is 11.1.
C, Your Lordship. No, D, Your Lordship. C is personal necessity.
नहीं चलेगा डिफॉल्ट का ग्राउंड intimation to the tenant is a very important step to change the landlord. And particularly when a suit for specific performance of contract was pending, जमशेदपुर में इस सब एडवाइस बहुत किया जाता है. It's famous for this. Bedrock of litigation. Correct? देखिए, learned counsel for the parties have commenced their arguments with respect to the question of law which has already been formulated by this court in the earlier order, and also the additional substantial question of law which has been allowed to be canvassed through the IA numbers and etc. It has been submitted that the property involved in this case, in which the appellant was the tenant, has been transferred in favor of the respondent by registered sale deed dated 8/2008, and the appellant during the pendency of title suit number 20 of 2007, which was filed by the appellant for specific performance of contract for the purposes of execution of unregistered deed of sale dated
22/2006.
Unregistered agreement of sale dated 22/2006 in favor of the tenant, and the tenant was already in possession of the property. That's it. As the court time is over, post this case for further hearing on Tuesday, Thursday at 2:15. Let this matter be treated as matter. अब अपना सीनियर लोग को ले आइए. ये जो अनरजिस्टर्ड डॉक्यूमेंट है, इसका कितना वैल्यू होगा?
This has been dealt with by the appellate court, but in a very cryptic manner. They have said that it will be known as if the delivery of possession is being seeked after the agreement, but we were already in possession.
नया जजमेंट है सुप्रीम कोर्ट का, देख लीजिए. Very recent judgment on this registration, 53A and specific performance of contract का. ठीक है, 53A में तो रजिस्ट्री जरूरी है, अब तो जरूरी है आफ्टर 2001 आई थिंक.
That has been also dealt with the appellate court judgment.
तो पास ओवर सबका क्या करें? आपका क्या है?
एक item number 10 and I cannot appear because deputy commissioner is party. Item number 11 I am ready.
11 में क्या है?
It may be kept on Monday, subject to your lordship's satisfaction.
सब लोग तो रेडी हैं अभी उठते समय.
नहीं हम तो
नहीं, देखिए, अगर आपको नहीं आप अपियर हो सकते हैं तो हम केस डीएफडी कर देंगे ना.
अब आई वाज आर्गुइंग
सो हम लोग नहीं, मेरा ये कहना है जिस केस में आप अपियर नहीं हो सकते, आप उसमें अपीलेंट है.
हाँ, इसमें item number 10 I am appellant. I have informed the appellant through registered letter and I have also telephonically informed. That is,
हाँ, but they are not taking any interest. Correct?
As your lordship is.
तब तो उसको डीएफडी ना करना पड़ेगा. आपने इन्फॉर्म कर दिया, चिट्ठी लिख दी, फोन कर दिया. अब हम लोग यहाँ से स्पेशल मैसेंजर तो नहीं भेजेंगे ना.
हमने लेटर हमने दिया, हमने लेटर भेज दिया.
बताइए कौन सा मैटर है वो? सीरियल नंबर बताइए.
10 ऐसे 381.
कब भेजा है आपने?
हमने भेजा है उनको 27/5/24 दो आदमी रजिस्टर्ड लेटर भेज दिया. शांति देवी विजय उराव, दो आदमी.
But still they are not taking any interest.
Telephonically Vijay has informed that he is in Raipur, and regarding other एक डेट दे दिया जब हम तो I cannot say because deputy commissioner is also party.
देखिए तो ये वाला second appeal number 381 of 2017. Learned counsel for the appellant Mr. Sanjay Kumar Tiwari has submitted that he has since he has become a counsel for the state, he is unable to appear in this case, as state is a party respondent.
Deputy Commissioner, yes.
As a deputy commissioner is party respondent in the second appeal. He has also intimated this court that he has issued registered letter to the appellant on to the
Appellant number 1 and 2.
to appellant number 1 and 2 on 27/5/2024,
Yes.
and has also telephonically informed them that he will not be able to appear in this case, and he has been informed that one of the appellant is in Raipur.
Yes.
Correct? He submits that in spite of information,
I have also informed the
fresh
counsel of
वकालतनामा has not been filed in this case. DFD नहीं करेंगे, ऐसे second appeal इस तरह से नहीं कर सकते. एक डेट दे के अगला डेट में कर देंगे.
Yes.
बोल दीजिएगा, order दे
I have also
दीजिएगा.
informed the counsel of the court below.
उससे कोई मतलब, counsel का कोई responsibility नहीं.
Because system proceeding also going on there.
Pose this case in order to give one more opportunity to the appellants to take steps in the matter. Pose this case on
Again, I will send later for their convenience.
18th of February 2024 in the supplementary cause list. If steps are not taken by the appellants, appropriate orders will be passed by this court, assuming that appellants are not interested in pursuing this case. Take?
Item 11 I am ready. If it is accepted in Monday or Thursday, any.
11 क्या है? अच्छा ये आपका इंडिपेंडेंट है.
हाँ इंडिपेंडेंट है, इसमें स्टेट पार्टी नहीं.
शैलेंद्र कुमार तिवारी कौन है?
वो तो नहीं आया. Respondent had the appeal has been admitted appeal.
जब पास ओवर दीजिए, हम इसमें कोई ऑर्डर नहीं करना चाहिए. आएगा अपने से 4:30 बजे के बाद ऑर्डर नहीं करना. वो जो एडजर्नमेंट ऑर्डर लिखा है ना, ये वाला ना, उस एडजर्नमेंट ऑर्डर में भी चाहिएगा हमको, अदरवाइज भी चाहिए.